Baffling and shocking. That is what a local judge said about the handling of evidence in a murder case by LMPD and the Florida lab it's using to process evidence.
In this WDRB Investigates follow-up, Valerie Chin explains the changes being made so it doesn't happen again.
Commonwealth versus Frederick Matthews, case number 23 CR 975.
Frederick Matthews is charged with burglary and murdering a 63-year-old man in March of 2023. But a roadblock is evidence testing in his case and how it was handled.
Potentially, there is no DNA evidence that links Mr. Matthews to this, and frankly, that might be exculpatory and helpful to him, and he might want those items tested. So, unfortunately, I think that we can't really do anything until testing is completed.
Because of a huge backlog of evidence, the Kentucky State Police Crime Lab, which is free for LMPD, the police department is using a private lab. LMPD is paying $2.3 million a year to use DNA Labs International in Florida for homicide, robbery, and sex crime cases. Police say faster evidence processing has led to crimes being solved faster.
There is evidence out there that needs to be tested, and we had a court order that allowed us to have our experts involved in the testing, and we don't now, we haven't had an opportunity to do that.
But in Matthews' case, Jefferson Circuit Court Judge Sarah Clay threatened to hold the lab in contempt. It's for failing to follow her orders to allow an expert for the defense to oversee evidence testing, which is the defense's right in Kentucky.
I do believe that there's a degree of potential arrogance or ignorance, or I don't even know what the term is, and not necessarily on the LMPD at this point, but at the staff or at the laboratory level itself. They're ignoring an order. They didn't read the order.
WDRB Investigates has learned LMPD and 6 people at the lab failed to read the judge's order and never contacted Matthews' attorney or the prosecution.
Whose job is it to make sure that the order is fully read by someone at LMPD?
I don't think anybody at LMPD. I guess it would be. I don't want to lie. I don't know who would fall under. I'm sorry.
I find it shocking that so many people would receive a copy of a court order that they are subject to and not read it.
The lab admits mistakes were made and new procedures have been put in place so this won't happen again.
Just for our laboratory specifically, meetings have already occurred company-wide to ensure that all personnel are aware of our steps moving forward.
In the end, the judge decided not to hold the lab in contempt.
The lab did not willfully violate the order. I think the fact that they failed to read the order, as well as everyone else who received the order, with the exception of the Commonwealth, obviously, Ms. Call, with the exception of the prosecutor involved in the case, will certainly not be a valid defense going forward, ever. Not just in this case, but in any other case, I would imagine, because they are certainly on notice now.
Matthews is scheduled to go to trial in May. With photojournalist Brian Manuel, Valerie Chin, WDRB News.
LMPD released a statement saying, in part, quote, steps have been taken to ensure that LMPD is reviewing the court orders before sending them to the lab. Web reporter Jason Riley explains how many other times the lab overlooked orders. You can read that story right now on WDRB.com.